Currently, there is much political debate about deportations to Syria. In September 2025, the Cologne Administrative Court dealt with such a deportation case. It ruled that the deportation was permissible. In this video, I'm going to speak about this judgment. There are two things I would like to mention first. The ruling only applies to this individual case. The Administrative Court only dealt with the question whether this specific plaintiff, in view of his specific circumstances, could be deported to Syria, where he would live in a specific region. The fact that the court deemed the deportation to be permissible in this case does not mean that all Syrians can be deported. And secondly, at the time of recording this video, the ruling is not yet legally binding. It is therefore still possible that it will be amended by the higher administrative court. So, what was the case about? The plaintiff in the case was a Syrian national. He entered Germany in August 2023 and applied for asylum. The Federal Office for Migration and Refugees rejected his application and informed him that he would be deported. The man filed a lawsuit against this decision. In his lawsuit, he stated, "I am entitled to asylum, and even if I'm not entitled to asylum, Germany must not deport me to Syria because that would lead to a violation of my human rights." The Administrative Court dealt with these questions. First, it examined the reasons that could give rise to right of residence. There are various categories of persons or group of persons who are protected in Germany on humanitarian grounds and who can then remain in Germany for their protection. The Administrative Court examined whether the plaintiff fell into one of these categories or belonged to one of these groups. And even if someone does not belong to one of these groups, there are cases in which they still must not be deported. For example, because the person would be at risk of certain violations of human rights if they were deported. The Administrative Court also examined this. The first questions the court examined was therefore whether the plaintiff belonged to a category of persons who are protected. The court first dealt with the question whether the plaintiff was a refugee. If someone is a refugee within the meaning of law, they enjoy protection in Germany. The Federal Office for Migration and Refugees recognizes the person as a refugee. The refugee then receives a residence permit and is allowed to remain in Germany, at least for a certain period of time. The Cologne Administrative Court therefore examined whether the plaintiff was a refugee. The term refugee is defined in Section 3 of the Asylum Act. It states that a refugee is someone who goes to another country for fear of persecution. The decisive factor is therefore that persecution exists. The plaintiff had stated that persecution resulted from the fact that he was subject to a form of military service in Syria. The plaintiff comes from northeastern Syria. Northeastern Syria is controlled by the Democratic Autonomous Administration of North and East Syria. This is a kind of de facto government and administration led primarily by Kurdish political forces. The Autonomous Administration has a military arm, the Syrian Democratic Forces. The Autonomous Administration has introduced a self-defense obligation. Men between the ages of 18 and 26 must serve in the self-defense forces for 1 year. The self-defense forces are a military unit that assists the Syrian Democratic Forces. They are not usually involved in combat operations. The question now was whether the plaintiff's obligation to perform this service constituted persecution. The Cologne Administrative Court said no. In the court's view, the self-defense duty is a type of military service, which is a civic duty. Having such a duty does not constitute persecution. Therefore, in the court's view, the plaintiff is not a refugee. The court then addressed the question of whether the plaintiff was entitled to subsidiary protection. If someone is not a refugee, they can still enjoy protection if they face serious harm in their country of origin. This is referred to as subsidiary protection. Subsidiary protection is regulated in Section 4 of the Asylum Act. The provision is based on an EU directive in which the EU has set out guidelines for member states on the conditions under which persons should enjoy international protection. According to Section 4, a person enjoys subsidiary protection if they face serious harm in their home country due to the death penalty, torture or inhuman or degrading treatment, or a serious threat from a conflict. The court must therefore determine whether the person concerned is at risk. In doing so, it relies on reports from international organizations, non-governmental organizations, or government agencies. On this basis, the court attempts to assess the level of risk of harm. In the case of the plaintiff, the court has come to the conclusion that the risk to the plaintiff is not so great that he is entitled to international protection. The court assumes that there are still isolated battles between the Syrian National Army and the military arm of the Autonomous Administration in northeastern Syria. Furthermore, the court stated that Islamic State has not yet been completely defeated there. However, the court is of the opinion that the number of civilian casualties caused by the conflict is relatively low. Therefore, the probability that the plaintiff could fall victim to acts of violence in the frame of conflicts is not particularly high. For this reason, he should not be granted subsidiary protection. Finally, the administrative court dealt with the question of whether a ban on deportation applied. The question of whether someone enjoys protection and therefore has a temporary right of residence must be distinguished from the question of whether someone can be deported to a specific country. There are situations in which someone is not entitled to asylum, is not a refugee, and is not entitled to subsidiary protection. This means that they have, in principle, no right to remain in Germany. However, deporting them to their country of origin would result in violations of their human rights. As a state governed by the rule of law, Germany cannot contribute to such violations of fundamental rights. For this reason, the Residence Act provides for bans on deportation in certain cases. The person in question does not actually have the right to remain, but is tolerated because deportation would involve violations of human rights. These bans on deportations are regulated in Section 60 of the Residence Act. On the one hand, a person may not be deported if the deportation would violate the European Convention on Human Rights. And deportation should not take place if there is a concrete danger to the life or limb of the person concerned. In some cases, these bans on deportation overlap with the requirements for international protection, but not always. Therefore, they must be examined separately. The Cologne Administrative Court therefore dealt with the question of whether deportation would violate the European Convention on Human Rights, namely the prohibition of torture or inhuman or degrading treatment. The court examined whether the plaintiff's living condition in the event of deportation to Syria would be so poor that the deportation would violate the prohibition of inhuman treatment. The court stated that poor humanitarian conditions in the country to which the person is to be deported only violate the prohibition of inhuman treatment if the conditions are exceptionally poor. It depends on whether the plaintiff would be able to satisfy his most basic needs in the foreseeable future. And here the court says, the economic situation in Syria is extremely poor. However, there are also some positive developments, such as measures supported by the World Bank. In view of contradicting development, the administrative court stated that the prospects for the plaintiff had to be assessed based on his individual circumstances. The plaintiff could live with his wife. Therefore, he would not have any rental costs. The plaintiff was a healthy young man with experience as a craftsman. It could therefore be assumed that he could work as a day laborer. In addition, he was entitled to return assistance. The court therefore assumed that although the plaintiff would be very poor in Syria, he would not have to live in existential hardship. Against this background, the court assumed that deportation would not violate the European Convention on Human Rights. The court therefore considered the deportation to be permissible.